You's a clown. That's what you. Why don't you call me a cardboard bishop now? You tough? Call me a cardboard bishop now.
He's not gonna call you that.
Huh? Look on Facebook Live. Call me a cardboard bishop now. You clown. That's what you are. You clown. That's what you are. Why don't you say what you say on Facebook Live, sucker?
No.
Yeah. So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest. Not a bit of accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge. They don't know they missing. Got a couple current events that you like. Wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect cause I'm sure y'all missing all the facts of the case that she steady is gifted. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. It's Pam Esquire, also known as Your Law Intellect. Before we get started, I know I have a cold, so I'm sure he's going to call me bald-headed and I sound like a man. But my daughter was sick, and now I'm sick. But I am here, despite all of this sickness, to come bring to you the latest as it pertains to Bishop Lamor Whitehead. You know, I told you guys that I wasn't going to come on unless there is more news when it pertains to him. That's why I haven't really been talking about him, because there wasn't anything that came out. But we have an order and opinion from the court today as it pertains to his criminal case. He is currently indicted on, we already went through the indictment. Of course, he is innocent until proven guilty. He has filed, and we went over in a previous video, a motion to suppress. And we'll go over that in the document where the court has made a ruling. And that came down today. All of the challenges that Whitehead has tried to proffer as it pertains to these warrants. We'll go over that. Let me speak to you guys real quick and then we'll get right to it because, you know, I feel like garbage right now. But I'm glad you guys are here with me. I'm glad for those of you that have gotten my notifications. I get a lot of comments and emails that you guys don't get them. I don't really know what to do about that except to try to give you a little bit of a heads up. So maybe you scroll past my name on YouTube and it comes across your feed. But other than that, I seem to get more notifications when it comes to Whitehead. So maybe that's the thing. But S. Johnson, thank you so much for being in here. Elise St. James, Jeff, Joyce, Uncle Vaughn, Jackie, J. Love, Sharon, Annette, Nessa. It's a lot of you guys up in here. Q the Prophet, Seal Wilson, TD, my sister's in the house. Jalen is in the house. All right, he said he got a notification. My son is always telling me how he never gets notifications. So I will. And I have so much to talk about, but I do have my lemon and my honey. We will go over, hopefully tonight, if I feel a little bit better, we'll go over the Trump indictment. I have read that. And then tomorrow I have a bunch of documents leading up to the Tory Lanez sentencing, whether it goes or it doesn't go. And then all of the drama behind the Tory Lanez case that has happened with bloggers over the last two days. It's been crazy. So we want to go through that thoroughly. Hopefully I'm feeling better tomorrow. But I couldn't wait another second before going over this stuff with Whitehead. So I decided to come on. So yes, he's probably going to say she's bald-headed and she sounds like a dude. But it's okay. It's okay. I'll take it on the chin. You said I got notification today, but it's been a while since. See what I'm saying? I don't know what it is. Maybe I have to put his name in every hashtag. I don't know what it is. Yeah, I heard about that as well. Thank you. Thank you, guys. Thank you. Yeah, shout out to my son for that intro. We're still waiting on the outro, too. Hello from Cincinnati. Thank you for joining us. So what we have, and it's very long. I'm going to try to get through as much as I can, but as you see, I sound like garbage. So I'm sure that it's going to sound like garbage to you guys. But I did want to, this is the opinion and the order. And in the beginning, the court kind of gives us a little summary on what Whitehead filed. So for those of you that have not been following me and have not looked at those documents of the motions that Whitehead filed, now you can see what they're talking about. And so it reads as follows. The superseding indictment charges defendant Lamor Whitehead with wire fraud, attempted wire fraud, attempted extortion, and making false statements to federal law enforcement officials, all in connection with a series of allegedly fraudulent schemes to enrich himself from approximately 2018 through 2022. Defendant seeks, number 1, suppression of statements made to law enforcement and dismissal of count 4 of the indictment, which is based on those statements. 2, suppression of evidence gathered from 9. There were 9 search warrants. And 3, hearing regarding the credibility of the government's confidential informant. We all heard about that confidential informant. And the veracity of the warrant affidavits. For the reason below, the motions are denied. So let's go over some of the background for those of you that haven't been up to date on this. The investigation of defendant began on or about April 22nd, 2022. When a business, now mind you, this is before the alleged robbery that occurred in July. When a businessman eventually called victim 2 in the indictment, contacted the U.S. Attorney's Office for the Southern District of New York regarding real estate partnerships proposed by defendant. Under this partnership, defendant promised victim 2 benefits based on defendant's relationship with various state and local government officials in exchange for a stake in real estate transaction and a $500,000 loan to defendant. This is what the victim alleges. The Federal Bureau of Investigation then conducted an investigation from around April 2022 through December 2022. So even when the alleged robbery occurred, according to this, he was under investigation during that time. So that would be April, May, June, July, August, September, October, November, December. So 9 months. When an indictment was filed. During the investigation, the FBI recorded communications between defendant and victim 2, which took place via phone, FaceTime, and in-person meetings. Somebody told me you can't record on FaceTime, but apparently you can. The government also collected evidence pursuant to 9 search warrants, all of which defendant challenges in this motion. The reason why he's challenging them is because if you have a search warrant and that search warrant was illegally obtained, or there wasn't probable cause for the search warrant, and the court would have suppressed it, that means anything that they found from that search warrant or anything that leads directly or indirectly from that search warrant is called fruit of the poisonous tree. And that means that they can't use any of that evidence. So if you guys watch Law and Order, I'm sure you guys have seen some of the shows where the defendant found something wrong with the search warrant. And then when the judge suppressed it, they do all this stuff in chambers, which I have never understood, instead of having it on the record, like out on the record in the court. But anyway, it is TV. If the judge grants it, then oftentimes the defense will say, well, I move to dismiss the case, because now you don't have any evidence, because everything that was derived from that warrant is fruit of the poisonous tree, and we're going to dismiss it. So that's what he was trying to do with these motions. Defendant's statements in the recorded conversations were in part the basis for the probable cause assertion in most of the government search warrant applications. Each of the warrants was issued by a magistrate judge who found probable cause to believe that the anticipated fruits of the search would reveal evidence of specified crimes. 8 different magistrate judges across 3 judicial districts issued the 9 warrants. Most relevant to this here motion, the indictment charges 1, a count of attempted wire fraud, alleging that defendant attempted to convince victim 2 to lend defendant approximately $500,000 and give defendant a stake in certain real estate transaction in exchange for securing favorable actions by the New York City government for victim 2, when defendant knew that he had no ability to obtain these actions. So now we want to know, how did the defendant know, or how did the government know that he didn't have the ability to obtain these favors? That's going to be interesting as this, comes out. And 2, a count of wire fraud, alleging that defendant obtained approximately $90,000 from victim 1, an individual who attended his church, with the false promise that he would use the money to assist victim 1 in obtaining a home. The indictment also charges defendant with attempted extortion for using threats of force to try to obtain $5,000 from a business owned by victim 2, with making false statements to federal officials as discussed below, and with wire fraud of Whitehead's efforts to obtain a $250,000 business loan based on allegedly material misrepresentations regarding the finances of Anointing Management Service, LLC. So are we all up to date on where we are today and how we got to this point? Let me see. You know what? Yes, that is the what is her name? Pauline Anderson. See, you guys know the fact it didn't come off the tip of my tongue, you guys know that I am feeling like garbage. Thank you so much, Cynthia Harrell, for the $2 super chat. I appreciate it. Hello, B. Laurel. Thank you so much. So let's read further. So then, motion to suppress defendant statements. Defendant moves to suppress statements that are the basis for count 4 of the indictment, which charges defendant with making allegedly false statements to the Federal Bureau of Investigation in violation of 18 U.S.C. Section 1001. He argues that use of the statement violates his Fifth Amendment privilege against self-incrimination because he previously said that he did not want to speak with law enforcement without an attorney present. This motion is denied because defendant was not in custody and was free to leave or refuse to answer the questions that elicited the statement. So essentially, the court said, listen, you were not under arrest. You were not in custody. All you had to do was walk away and not even talk to them. They couldn't make you talk to them. So if you chose to talk to him and give him information, then that's pretty much on you. Because you could have just left and said, well, am I under arrest? Well, if I'm not under arrest, this is pretty much what you tell your clients. If I'm not under arrest, then I want to leave now. Or if you are going to, I would like to invoke my right to an attorney if you're in custody. So let's give some background. On June 8, 2022, 4 FBI agents drove to defendant's home in Paramus, New Jersey to execute a warrant authorizing the seizure and search of all Apple iPhones on defendant's person. After seeing their vehicle, defendant came out of his home and approached them. The agents then served the personal warrant, conducted a pat-down search, and seized from defendant's pants pocket an iPhone with a call number ending in 3314. After reading the personal warrant, defendant said that he did not want to speak with law enforcement without an attorney present. One of the agents then held the 3314 phone as defendant scrolled through it to write down numbers. Afterwards, the agent informed defendant that a separate search warrant had been issued for defendant's church in Brooklyn, New York, and requested defendant's assistance with opening the premises to avoid forced entries, of which defendant agreed. For roughly the next 20 minutes, defendant came in and out of the house, coming outside to obtain phone numbers from the seized phone and returning inside, ostensibly to call someone who could open the Brooklyn church. When the agents asked defendant whose phone he was using to make the calls, defendant said he was using his daughter's phone. One of the agents then asked if the defendant had another phone he could be reached on so that they did not have to stand in the driveway. Defendant said he did not. An agent then asked a second time, in essence, quote, "You don't have a second cell phone that belongs to you that we could call you on?" And defendant again said he did not. The agents left after obtaining from defendant the phone number of the landlord of the Brooklyn church. Defendant's statements that he had only the 3314 phone and no second phone are the basis for the false statements charged in count 4 of the indictment. The standard here is the Fifth Amendment guarantees that no person shall be compelled in any criminal case to be a witness against himself. You know how people just plead the fifth? I had somebody plead the fifth today in a deposition because they thought that if they gave information, it may bring criminal charges sometime in the future. U.S. Constitution Amendment 5. Under the right against self-incrimination, the prosecution may not use statements stemming from custodial interrogations of the defendant unless it demonstrates the use of procedural safeguards effective to secure the privilege against self-incrimination. That's Miranda versus Arizona. For any of you guys that don't know, that is where the word Miranda rights come from. Miranda versus Arizona. An interrogation occurs when a suspect is subjected to either express questioning or its functional equivalent, and his statements are the product of words or actions on the part of the police that were reasonably likely to elicit an incriminating response. Determining whether an individual is in custody is an objective inquiry that asks, 1, whether a reasonable person would have thought he was free to leave the police encounter at issue, and 2, whether a reasonable person would have understood his freedom of action to have been curtailed to the degree associated with formal arrest. Although both elements are required, the second is the ultimate inquiry because a free to leave inquiry reveals only whether the person questioned was seized. Then he gives a bunch of prongs on considerations on the second inquiry. The defendant was questioned does not mean that he was in custody. Even assuming he was, quote, interrogated, the law enforcement member did not subject defendant to a custodial interrogation when they executed the personal warrant. The agents remained in the driveway during the entire encounter and never entered defendant's home. They did not place defendant under arrest, handcuff him, or draw their weapons. Defendant walked in and out of his home freely. Only 4 agents executed the search warrant. Okay. In the parentheses are different summaries of what these cases are. So I'm trying to skip over those because we'll be here all day. A reasonable person in defendant's shoes would have felt free to leave under the circumstances. As defendant was not subjected to a custodial interrogation during the execution of the personal warrant, defendant's cited cases do not apply. So basically they said you wasn't in custody, so you were free to leave. And that's that. Let's see what else the opinion has to say. Oh, let's read this part. Defendant's statement that he did not want to speak with law enforcement without an attorney present does not mandate suppression of the statements he made afterwards. Defendant argues the agent should not have questioned him after he made this statement. But the Supreme Court has, quote, never held that a person can invoke his Miranda rights anticipatorily in a context other than custodial interrogation. So essentially they're saying, like, Supreme Court has never said just because you think you might be arrested is not a reason to invoke your Miranda rights, which is, you know, you have the right to remain silent. Anything you say can and will be used against you. You have a right to attorney, you know, all of that we hear. As defendant was not in custody at the time, he remained, quote, in control and only needed to, quote, shut his door or walk away to avoid police badgering. While a person is not obligated to answer questions about law enforcement, whether in custody or not, defendant willingly chose to answer questions after saying that he did not want to do so without an attorney. Defendant cited cases are an opposite as they concern the right to remain silent. Let's see. Defendant's argument that Whiteheads did not make a false statement because he did not have a second phone, but not one that the FBI could call him on, is also unavailing. Wait a minute, let me read that again. Defendant's argument that Whitehead did not make a false statement because he did not have a second phone, but not one that the FBI agents could call him on, is. So are they saying he didn't lie because the way the FBI worded the question, when the FBI said, you got another phone we can call you on? So he's saying in his mind, yeah, I may have another phone, but you can't call me on that phone. I think that's what they're trying to say. As no Fifth Amendment violation occurred, defendant's motion to suppress his allegedly false statements and to dismiss count 4 of the indictment is denied. Motion to suppress seized evidence. Defendant moves to suppress evidence from 9 search warrants, challenging each on the ground of lack of probable cause, lack of particularity, and overbreadth. For the following reasons, these motions are denied. In the standard, the Fourth Amendment provides that no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Because the right assured by the Fourth Amendment are personal, courts suppress evidence only at the instance of one whose own protection was infringed by the search and seizure. In other words, the defendant must have standing to bring a suppression motion. Okay. Let's go through some of this. Let's see what probable cause is. Maybe some of you guys don't know what probable cause is. Probable cause exists when the totality of the circumstances indicates a fair probability that contraband or evidence of a crime will be found in a particular place. That is what probable cause is. Probable cause is not a high bar. It definitely is not. Court should pay great deference to a magistrate judge's determination of probable cause. To satisfy the Fourth Amendment's particularity requirement, a warrant must meet 3 criteria. It must identify the specific offense for which the police have established probable cause. 2, it must describe the place to be searched. And 3, it must specify the items to be seized by their relation to designated crimes. All right. Let me keep going. Let me go to standing. Defendant, you see it's long. It's like 25 pages. Defendant has established standing to challenge each of the search warrants except for the Brooklyn church warrant. Defendant has shown that he has a reasonable expectation of privacy in a cell phone with an assigned number ending in 9839. The 3314 phone set his New Jersey home as he has claimed ownership of them in a supporting affidavit. So he has the right to bring this motion and try to suppress as it pertains to his own personal stuff, because you have a right to privacy in your cell phones, in your house, things of that nature. However, with the church, they're saying you really didn't have that. They said defendant does not have standing to challenge the Brooklyn church warrant. He has not claimed ownership of the church nor any other legally cognizable privacy interest in the search premises at the time of the search. So that would have been the church, right? Would that have been the storefront church, or maybe that was at a different church? You guys let me know. I think that was the church that the alleged robbery happened in. You see? He can be bald-headed, but guess what? You are not. You know what? I think, don't quote me on it because I don't want anybody saying I'm telling lies on them. I believe it was the storefront church that was actually robbed. That is what they're talking about. Allegedly robbed. I don't want them people coming for me neither. So it says, absent a showing of ownership or other privacy interests in the church, Whitehead has no basis to challenge the Brooklyn church warrant on Fourth Amendment grounds. His motion to suppress the fruits of the search from the Brooklyn church warrant is denied for lack of standing, and in the alternative for the reasons discussed below. So now we got warrants relating to victim 2. We know who victim 2 is, allegedly. On June 7, 2022, the personal warrant was issued authorizing the search of any Apple iPhone carried by Lamor Whitehead or in clothing, bags, or containers worn or carried by him at the time of the search. The affidavit supporting the personal warrant establishes probable cause. The affidavit details the weeks-long investigation at that point of defendant, including multiple recorded phone conversations with victim 2, in which defendant discussed leveraging his relations with New York state and local officials for monetary gain and real estate transactions. The affidavit states that during the FaceTime exchange, the defendant spoke with victim 2 using the 3314 phone, but showed victim 2 a second iPhone with documented contacts between defendant and a New York City government official. Official what? What? Contrary to defendant's assertion, there was a fair probability that a search of iPhones on defendant's person would reveal evidence of crimes. Defendant challenges the trustworthiness of the confidential informant, but the warrant affidavit explicitly asked the court to consider victim 2's statement to law enforcement only as context for later recorded statements made by Whitehead and for not making probable cause determination. So the warrant wasn't based on victim 2, according to them. The warrant was based on probably the recordings. And then they just mentioned victim 2 to give it background. You know how sometimes, like in the beginning, where I'm like, yeah, if you haven't been following me, you may not know what I'm talking about. So I need to give you some background information before we get to the meat of what we're doing today. So that's what it sounds like they were just trying to do, was to give some type of context by using victim 2's statement for context purposes, but not for probable cause purposes. As context for later recorded statements made by Whitehead and not for making probable cause determination. The credibility of the confidential informant is irrelevant since probable cause was sufficiently established by defendant's own recorded and incriminating statement. So essentially, they saying victim 2 don't matter whether he credible, not credible. If he got 20 cases himself, whatever his issues are, they didn't rely on him anyway. So the warrant is sufficiently particularized. It, number 1, identifies the specific offenses for which probable cause is established: wire fraud, extortion under color of official right, aiding and abetting in conspiracy. 2, describes the property to be searched as, quote, any Apple iPhone carried by Lamor Whitehead. And 3, specifies the type of evidence targeted by the ESI review of the iPhones based on those alleged crimes, including communications with or about New York government officials. Evidence concerning real estate investment or transactions, and evidence concerning the finances of Lamor Whitehead. Contrary to defendant's arguments, this warrant is not overbroad. Defendant contends this warrant is overbroad because agents were less certain it authorized the seizure of evidence relating to schemes involving victim 1, who was not a part of the probable cause recitation, which addressed victim 2. This argument fails because the personal warrant enumerates the type of evidence to be seized from Whitehead's iPhones, including, quote, evidence concerning real estate transactions, end quote. And these items are not, quote, wholly unrelated to the crimes for which probable cause was established, end quote. Defendant cites no case law that requires the warrant to limit the relevant crimes. Defendant cites no case law that requires the warrant to limit the relevant crimes to those involving particular victims. Here, the agents properly seized evidence concerning real estate investments or transactions relevant to wire fraud, which involved both victim 1 and victim 2. How y'all doing out there? You guys okay? You are quite welcome. I know. If I was making hundreds and thousands of dollars, somebody owes me money. They really do. They owe me money for this. I'm not making hundreds of thousands of dollars. I'm not making tens of thousands of dollars. What are you talking about? Okay, just making sure you guys are all right. Making sure you guys are. So are we ready to move forward? Ready to move forward? Okay. Let me see if there's any questions. Who's the attorney on which case? And who's the attorney on for his criminal case? Y'all help her. Yes, y'all help me get my hundreds and thousands of dollars. I'm up here sick and I'm on here reading these documents, keeping you guys up to date. Oh, thank you so much. All right, let's proceed. The Brooklyn Church warrant. On June 7, 2022, the Brooklyn Church warrant was issued, authorizing the search of a Brooklyn church believed to be run by defendant. The Brooklyn Church warrant is supported by probable cause. The warrant affidavit describes defendant's recorded statements to victim 2 that he keeps guns in the church, and it identifies the church. Excuse my baby, guys. Sorry. The warrant affidavit describes defendant's recorded statements to victim 2 that he keeps guns in the church, and it identifies the church location based on the church's online page, in-person surveillance, and telephone confirmation. The warrant satisfies the 3 criteria for the Fourth Amendment particularity requirement. It 1 identifies the specific offense for which probable cause is established. Lawful possession of a firearm. 2 describes the property to be searched as the location for Whitehead's alleged church. And 3 specifies the types of evidence targeted by the search based on the alleged crime, including evidence concerning occupancy or ownership of the Brooklyn church, and firearm ammunition and firearms accessories. Oh my goodness. Phone location of the warrant. On June 17, 2022, a warrant was issued, authorized the release of prospective and historical location information for the 9839 phone. The government sought historical location information from June 7, 2022 to the time of the warrant's issuance, as well as prospective information for the next 45 days. The warrant also authorized the release of toll records and pen register information. The affidavit supporting the warrant establishes probable cause that this information will reveal evidence of false statements and obstruction of justice crimes. It recounts Whitehead's denial of a second cell phone during the execution of the personal warrant and notes that law enforcement believed the 9839 phone to be defendant's second phone based on at least one text message from defendant 3314 phone that identified the 9839 phone on a second phone number for the user of the 3314 phone. 2, a saved contact for my phone on the 3314 phone that listed the 9839 phone. And 3, a Facebook page of defendant's alleged church that listed the 9839 phone as the church's phone number. He had it on there, my phone, in his contacts. Wow. Oh, goodness. Oh, my goodness. All right. Defendant challenges the 9839 phone location warrant on the basis that the supporting affidavit omits the fact that a conversation between defendant and victim 2 may have taken place in person rather than over the phone. But defendant has not shown how this omission, even if true, would affect the probable cause analysis. The warrant is sufficiently particularized and not overbroad. It, one, identifies the specific offenses for which probable cause is established, false statements and obstruction of justice, describes the property to be searched, and specifies the types of evidence targeted by the warrant, the phone's location, toll records, and PIN register. None of the descriptions are broader than can be justified by the probable cause upon which the warrant is based. The warrant seeks information about the 9839 phone for the period from June 7 for 45 days, the warrant issuance date. June 7, 2022 is the only one day before the FBI agents execute the personal warrant in question defendant about the ownership of the second phone. So they said that's not going to fly. The June home warrant is 9 warrants. I did not even know it was that many. But well, I knew from the last video, but I think at first when we started, we didn't know it had been that many warrants. On June 27, 2022, a warrant was issued authorizing the search of defendant's residence. The warrant authorized the seizures of the 9839 phone, defendant's second iPhone. The June home warrant is supported by probable cause, as the supporting affidavit notes that the 9839 phone is listed as the phone number for the church, allegedly led by the defendant. They say allegedly led by defendant. Number 2, a phone call was placed from the 9839 phone to official 1 after the 3314 phone was seized, and 3, location data for the 9839 phone revealed its presence at defendant's residence. The June home warrant is sufficiently particularized as it, 1, identifies the specific offenses for which probable cause is established: wire fraud, extortion under color of official right, aiding and abetting, conspiracy, false statement, and obstruction of justice. 2, describes the property to be searched at Whiteheads, New Jersey home. And 3, specifies the type of evidence targeted by the ESI review of the 9839 phone based on those alleged crimes, described in 9 categories similar to the ones in the personal warrant. Defendants, this was his argument. Defendant's argument that the June home warrant is overbroad because it authorizes the search of an entire house instead of only the areas where the cell phone are likely to be found fails. And that's United States versus Ulbricht. A warrant may allow the government to search a suspected drug dealer's entire home where there is probable cause to believe the evidence relevant to that activity may be found anywhere in the residence. And then they give more case law. Oh my goodness. So then they talk about the 9839 and the 3314 phone locations warrant. You guys still with me? You guys still with me? I just want to make sure I don't lose anybody. New York and New Jersey. Wait, New York and Jersey, but be behind in paperwork because 9 warrants and you harassing people online is, you know. Well, wow, preaching and praying online, but moving like a criminal when nobody's looking. It's a lot going on here. I just want to make sure you guys are with me because it's a lot. This opinion is a lot. But we did go over his motion. We went over it both times. We went over the one where the first one they filed, and I guess it was done in a rush job manner because it was the deadline. And then they did a whole nother one, and we went over that as well. So, and we went over the government's response because we're always fair on both sides. And just to be clear, I believe that his attorney should have filed motions to try to suppress. A lot of this stuff is kind of par for the course where, you know, if you can get a win suppressing evidence, and like I said, it'll be fruit of the poisonous tree, and then you can eliminate all of that, and you may be able to say, I want to dismiss this case. So I understand the reasoning why they did it. Now, as he sees, though, now it's public record where we probably wouldn't have had all this information because what happens is hold on one second. The criminal case. Okay. The criminal attorney for Whitehead is Don Florio. Somebody was asking that. The criminal attorney for Whitehead is Don Florio. I forgot my thought. My husband was texting me. And you guys, sorry, I lost my thought. I'm going to go back to the document. See, my brain's all foggy right now. Okay, on August 8th, 2022, a warrant was issued authorizing the release of historical location information for the 9839 phone, 3314 phone, and 2 phones used by victim 2. The government saw historical location information from April 1st, 2022 to June 29th, 2022. The warrant also authorizes the release of the phone's toll records. The supporting affidavit establishes probable cause that this information would reveal evidence of wire fraud, conspiracy, false statement, and obstruction of justice as it recounts 1, the investigation launched after victim 2 approached law enforcement about Whitehead's proposed real estate ventures with victim 2, and 2, the role of these phones in the alleged crimes. I want to know who these officials are that were in the phone. Don't you guys want to know that? I just want to know who they are. I'm sure they're not going to reveal them to us, like in none of these documents. But I'm just curious. The warrant is sufficiently particularized. It, 1, identifies the specific offenses for which probable cause is established as listed above. 2, describes the property to be searched as the 9839 phone, 3314 phone, and 2 phones used by victim 2. And 3, specifies historical location information and toll records as evidence targeted by the warrant. The warrant is not overbroad, as the warrant authorizes historical location information for the period when defendant allegedly spoke with victim 2 regarding the real estate ventures. Warrants relating to victim 1. September 9839-3314 phone contents. On September 21st, 2022, a warrant was issued authorizing the review of ESI contained on the 9839 and 3314 phones for evidence, fruits, and instrumentalities of violations of wire fraud, conspiracy, and money laundering statutes. As described in 9 categories focused on the alleged scheme to defraud victim 1 of the $90,000, she sent Whitehead to help her purchase a home. The affidavit supporting the September 9839 and 3314 phone contents warrant establishes probable cause that this information will reveal evidence of the alleged crimes, as it notes that 1, the case team had reviewed a verified civil complaint alleging that defendant had defrauded victim 1 of her life savings. 2, the allegations on the complaint are consistent with Whitehead's prior criminal conduct. And 3, review of the 9839 and 3314 phones based on prior warrants had confirmed defendant as the user of both phones. And we all know this is the civil complaint we went over from Pauline Anderson. We also, this was probably 8 months ago. We went over that civil complaint with all the attachments to it as well. Defendant challenges this warrant along with the 3314 phone location warrant in October 9839 and 3314 phone content warrant defined below on the grounds that the supporting affidavit references the civil suit filed by victim 1 against defendant in support of its probable cause finding. This civil suit arises out of the same events described in the indictment. Contrary to defendant's argument, a civil complaint can, CAN, provide the basis for probable cause if its allegations are, quote, reliable enough to establish probable cause, end quote. The core question when assessing the existence of probable cause based on an informant's information. The reliability of the civil complaint is further supported here by the fact that it was verified. That means she signed it. Meaning the victim 1 made her allegations under threat of criminal sanction for perjury. The civil complaint did not need to plead each of the elements of the federal wire fraud charge for the issuing judge to have found probable cause. The probable cause analysis is based on the totality of the circumstances. if you guys recall, when Whitehead was talking about, I don't know what platforms he went on. I can't remember, but I'm sure somebody sent it to me. When that occurred, thank you so much, Cupcake. I appreciate it. When he went on these other platforms, I think there was a statement, if I recall correctly, that how were they able to indict based on a civil complaint. So this is what the court is addressing right now. Cupcake says, for your hundreds of thousands of dollars and some tea with honey and lemon, feel better. Thank you so much. I appreciate it. I appreciate the love. Defendant also challenges the references to defendant's, quote, prior convictions in the affidavits supporting both this warrant and the October 9839 and 3314 phone contents warrant. But these convictions, quote, are relevant consideration in determining probable cause. However, even assuming defendant's prior convictions are too, quote, stale to establish probable cause, the other facts in the supporting affidavits establish probable cause. So in this, they've also, according to this, utilized his prior convictions to aid in their assessment of probable cause. But the court said even if, they decided not to even mention your prior convictions, there was still enough supporting facts to establish probable cause. So they're saying the warrant is sufficiently particularized and not overbroad. It, one, identifies the specific offenses for which probable cause is established, as listed above. Two, describes the property to be searched as the 9839-3314 phones. And three, specifies the type of evidence targeted by the ESI review of the iPhone based on the alleged crimes, including all communications with or about victim one or victim one's son, or about money obtained from them. All communications or documents regarding the finances of Lamor Whitehead and all entities associated with Whitehead, and all communications or documents regarding allegations of fraud by Lamor Whitehead or any entity associated with Whitehead. The warrant is not overbroad, as none of the descriptions are broader than can be justified by the probable cause upon which the warrant is based. And there's more, guys. There's more. Thank you guys for the cash apps. I appreciate it. I'm going to shout you guys out in a minute. On November 23rd, 2022, a warrant was issued authorizing the release of historical location information and toll records for the 3314 phone. The government saw historical location information from May 1st of 2020 through June 15th. They can go back that far? I didn't even know they can go back that far. Wow. The government saw historical location information from May 1st, 2020 through June 15, 2021. The affidavit supporting the 3314 phone location warrant establishes probable cause that this information would reveal evidence of wire fraud, conspiracy, and money laundering, as the affidavit recounts the alleged series of events that led victim one to file her civil suit against the defendant based on interviews with victim one and her son, as well as text messages among the three of them that involved both target phones. The warrant is sufficiently particularized and not overbroad. It, one, identifies the specific offenses for which probable cause is established as listed above. Two, it describes the property to be searched as the 3314 phone and the phone believed to be used by victim one's son. And three, specifies the type of evidence targeted by the warrant. The warrant is not NOT overbroad, as it authorizes this information from the time period when victim one conducted her housing search. Whew. Additional warrants. October 9839 and 3314 phone contents. On October 6, 2022, a warrant was issued authorizing the review of ESI contained on 9839 and 3314 phones for evidence, fruits, and instrumentalities of violation of attempts to commit theft of federal funds and wire fraud and conspiracy to commit the same. As described in 5 categories focused on Whitehead's 2021 candidacy for Brooklyn Borough President. The warrant affidavit establishes probable cause that this information will reveal evidence of the alleged crimes, as it notes: 1, the same verified complaint discussed above, alleging that defendant had defrauded victim 1. 2, Whitehead's prior criminal conduct. 3, an interview with victim one's son that recounts Whitehead's alleged attempt to fraudulently obtain matching funds. Oh, so it was an interview with victim one's son that recounts Whitehead's alleged attempt to fraudulently obtain matching funds from the New York City Campaign Finance Board by filing false campaign contribution cards, and 4 images of the contents of victim one's son's phone that show related communications with Whitehead. The warrant is sufficiently particularized and not overbroad. It, 1, identifies the specific offenses for which probable cause is established as listed above. 2, describes the property to be searched as the 9839 and 3314 phones. And 3, specifies the types of evidence targeted by the ESI review of the iPhones based on alleged crimes, including evidence of a scheme by Lamor Whitehead and others to obtain New York City funds based on false claims that he had received certain contributions to his 2021 campaign for the Democratic Party nomination for Brooklyn Borough President, and, quote, all communications or documents regarding the finances of Lamor Whitehead's 2021 campaign for Democratic Party nomination for Brooklyn Borough President. The warrant is not overbroad, as none of the descriptions are broader than can be justified by the probable cause upon which the warrant is based. Whew. You guys got to get these likes up. I'm over here working. So now this warrant, according to this, it was victim one's son who perhaps may have worked on the campaign, who also interviewed with the FBI and provided some information that he alleges occurred related to campaign finance matching. That's what was in the prior. There was a, I don't know if it was the government's motion. It might have been the government's response to their motion where the government mentioned that. So that became headlines for a minute about the matching funds. This is what they're referring to right now. I just can't right now. Okay, I need you guys to be all eyes on, all the minds be on deck. Dev is working, so I can't. Need y'all to be on deck. Look out for him in the chat. Because I've been getting some crazy comments after the fact. I've been doing a lot of blocking and deleting. Block, delete, block, delete. I've been doing a lot of that in the last week. December home warrant. We getting to the home stretch. On December 16, 2022, a warrant was issued authorizing another search of defendant's residence. The December home warrant is supported by probable cause, as the supporting affidavit describes the investigation into Whitehead's various alleged crimes up to this point, including his interactions with victim 1 and victim 2, and notes Whitehead's submission of an allegedly fraudulent application for $250,000 business loan for Anointing Management Services, LLC, as well as his use of 2 bank accounts to funnel victim 1's $90,000 investment into paying for his personal expenses. The December home warrant is sufficiently particularized and not overbroad. It, 1, identifies the specific offenses for which probable cause is established: wire fraud, attempted wire fraud, extortion under color of official right, and concealment money laundering. 2, describes the property to be searched as Whitehead's New Jersey residence. And 3, specifies the type of evidence targeted by the search based on those alleged crimes, including, quote, financial records for Lamor Whitehead and any entity controlled by or associated with Lamor Whitehead, and electronic devices, including cell phones, laptops, and tablets owned or used by Lamor Whitehead, here and after the seized devices. The warrant also authorizes a search of these devices for evidence of those alleged crimes as described in 9 categories, including, quote, evidence of a scheme by Lamor Whitehead to defraud victim 1, end quote, evidence of Lamor Whitehead's relationship, including nature, scope, and duration with New York City officials, end quote, and, quote, evidence regarding the identity of the owner or user of the seized devices at times relevant to the alleged crimes. None of the descriptions are broader than can be justified by the probable cause upon which the warrant is based. Then there's the good faith exception. So even if the warrants were defective, the good faith exception would apply to each of them because the agents executing the warrants acted with an objectively reasonable. Hold on one second. Let me see what's wrong with my page. Sorry about that. Okay, so even if the warrants were defective, the good faith exception would apply to each of them because the agents executing the warrants acted with an objectively reasonable good faith belief that their conduct was lawful. The nexus of facts in each case justifies searches of Whitehead's persons, phones, residence, and alleged church. None of the four limitations on the good faith exception applies. Defendant argues that certain of the warrant applications unreasonably rely on information from victim 2, pointing to victim 2's suggestions to an FBI agent that victim 2 start a fraudulent company. However, as is evident from the FBI Form 302 that reports this suggestion, victim 2 made the proposal as a way to maintain defendant's interests and doing business with him as a cooperating witness, and not from any desire to engage in illegal conduct. Thus, no good faith exception applies. Defendant also challenges an agent's initial review of Whitehead's 2 iPhones for evidence of the alleged scheme to defraud victim 1 of $90,000 based on the personal warrant and the June home warrant before the issuance of the September 9839 and 3314 phone contents warrant. A footnote in the supporting affidavit of the September 9839 and 3314 phone content warrant explains that an agent had begun reviewing Whitehead's 2 iPhones for evidence of the allegations of victim 1's civil complaint, which the agent believed permissible under the previously issued warrants. Nevertheless, the footnote states that the case team was applying for the September 9839 and 3314 phone content warrant, which focused on Whitehead's alleged scheme to defraud victim 1 out of an abundance of caution. Defendant's challenge fails, F-A-I-L-S, because both the personal warrant and the June home warrant authorizes the search of the devices for evidence concerning real estate investments or transactions, whether or not completed, and evidence concerning the finances of Lamor Whitehead or of any entity that Whitehead owns, manages, operates, or has invested in. Now let's go to the motion for a hearing. Defendants seek both a so-called Darden hearing and a Franks hearing based on the following statements in 6 of the warrant affidavits. The government, quote, is not asking the court to rely on victim 2's statement to law enforcement in making its probable cause determination. Rather, victim 2's statement to law enforcement are provided as context for later recorded statements made by Whitehead on which the court is asked to rely. From this statement, defendant deduces that victim 2 is unreliable and that the warrants are potentially tainted as a result. For the reason below, the requests for the hearing are denied. So if you guys recall, because of who victim 2 is and how Whitehead was asking everyone to look at his background, which we did. The dude does have a background. I mean, there were cases, there were a plethora of cases, whatever. So because of that, I guess because the FBI opted not to use what victim 2 said verbatim for probable cause, they asked the court not to rely on that because they had other ways that they can show probable cause. So what they argued is you must have known he was unreliable if you didn't want to use his statements. The government is saying we ain't needed statements. We already had what we needed to get probable cause, which is all the bar and the standard is. So he was arguing essentially in this, that because the guy was so unreliable and the government knows he's unreliable because they chose not to utilize his testimony. Sorry. The government was like, no, that's not how this goes. Let me pull this back up. I don't even know what happened. Just blinking out. Okay. All right. Sorry about that, guys. The Darden hearing, defendant seeks a so-called Darden hearing to inquire into the reliability of victim 2. A Darden hearing is a state court procedure in criminal cases where, when evaluating a motion to suppress, the court may conduct an ex parte, in-camera examination of a confidential informant without disclosing the informant's identity to the defendant. A Darden hearing is warranted where there is insufficient evidence to establish probable cause apart from the testimony of the arresting officer as to communications received from the informer. Defendant request for a Darden hearing is denied, first because it's exclusively available under New York state law. This is a federal case. And second, because the warrants in question were sufficiently supported by probable cause established by defendant's own incriminated recorded statement. They said they did not need his statement. Your own incriminating statements got you. That's what the court said. That's not what I said. So don't get mad at me. Why is this not coming up? Let's take a quick intermission here.
You's a clown. That's what you. Why don't you call me a cardboard bishop now? You tough? Call me a cardboard bishop now.
He's not gonna call you that.
Huh? Look on Facebook Live. Call me a cardboard bishop now. You clown. That's what you are. You clown. That's what you are. Why don't you say what you said on Facebook Live, sucker?
No. You got it?
Now let's go on to the Franks hearing that he requested. Let's find out what a Franks hearing is. A Franks hearing permits a criminal defendant to challenge the veracity of a warrant affidavit under certain circumstances. To trigger the hearing, a defendant must make a substantial preliminary showing that 1, the warrant application contains a false statement, 2, the false statement was included intentionally or recklessly, and 3, the false statement was necessary to the finding of probable cause. The deliberate falsity or reckless disregard whose impeachment is permitted today is only that of the affiant, not of any non-government informant. The Frank standard is a high one, and that's Riviera v. United States. The fruits of the search must be excluded if the allegations of perjury or recklessness is established by a preponderance of the evidence in the affidavit's remaining content with the falsehood set aside is insufficient to establish probable cause. To mandate an evidentiary hearing, the challenger's attack must be more than conclusory and must be supported by more than a mere desire to cross-examine. Defendant has not met the standard required for a Franks hearing. Defendant has failed to make a substantial preliminary showing of any of the 3 requirements for a hearing. First, defendant has not identified any false statements by an affiant, much less that an affiant intentionally or recklessly included such a statement. Defendant has also failed to make a substantial preliminary showing that any affiant's representation of information from victim 2 was necessary to a finding of probable cause. To the contrary, for each of the 6 warrants, defendant's own words, they keep saying your own words, in the form of his recorded conversations were sufficient to establish probable cause. Under these circumstances, no hearing to challenge the veracity of the search warrant affidavits is warranted. Defendant's request for Frank's hearing is denied. Conclusion. We made it to the end. We have made it to the end of this 25-page opinion. For the foregoing reason, defendant's motion for suppression of statements made to law enforcement, suppression of evidence gathered from nine search warrants and hearings regarding the credibility of victim 2 and the veracity of the warrant affidavits are denied. Defendant's request for oral arguments is denied as moot. The government's request to file a cert reply already submitted in response to defendant's reply to his first motion to suppress is granted non-pro-tunc. And the clerk of the court is respectfully directed to close the motion. So essentially, the government had already did a reply. They must have asked the court, and the court didn't respond. So the court is like, yep, we considered your reply, and we'll backdate it. That's what non-pro-tunc is. And that's it. That's what we have. We have that the motion for suppression.
You's a clown. That's what you. Why don't you call me a cardboard bishop now? You tough? Call me a cardboard bishop now.
He's not gonna call you that.
Huh? Look on Facebook Live. Call me a cardboard bishop now. You clown. That's what you are. You clown. That's what you are. Why don't you say what you say on Facebook Live, sucker?
No.
And there we have it. We have the motion. Again, I told you when we got the court's response that I will come to you fresh off the press, which I did. It just came down today. We will go over the court's opinion. That's what we have done over the last hour. If you guys are just joining, please make sure that you hit that like, subscribe. We are following and trying to conclude the cases that we started related to Whitehead. And let me see if y'all got any questions, and then I'm going to be out of here. Denied. I mean, if you guys are just joining, you guys got to go all the way back to the beginning, because this was a long journey down this opinion. And I'm sure other content creators will probably cover it. They probably won't go over the whole document like that, but you know, they can summarize it. Thank you, Shamika, for the Cash App. Deborah, thank you. Jacqueline, Keisha, Katrina, LaVersa, and Catrice. Thank you so much. I appreciate you for supporting the platform and supporting the work that we're trying to do over here. Thank you, Pam. Get you some rest out, baby. Your best reading all that for us. Thank you so much. Thank you, guys. Thank you, guys. I will be back tomorrow to talk about Tory Lanez. I want each and every one of you guys to come back. If I feel a little better, I may do like a late night situation to talk about Trump's indictment, because I do have that. That's what I really plan on talking about today. But once this came down, I said I'll use my energy to talk about Whitehead. So, yeah. Yes, I have it in there already. Thank you for the suggestions. I really appreciate it. Thank you all for all the donations. And, you know, we got to hit one for the road. Give you guys your laugh for the road. But we'll be back. Make sure you join me again tomorrow at noon.
You's a clown. That's what you. Why don't you call me a cardboard bishop now? You tough? Call me a cardboard bishop now.
He's not going to call you that.
Look on Facebook Live. Call me a cardboard bishop now. You clown. That's what you are. You clown. That's what you are. Why don't you say what you say on Facebook Live, sucker?
No.